Thank you for tuning in to this training video prepared by the Southeastern Connecticut Council of Governments. If you are a member of a municipal zoning board of appeals, this video is for you. We're going to go over some of the basic functions of a ZBA and talk a little bit about the types of applications you might come across. At the end, we'll go through an example of a variance application with some questions to test your knowledge, so stay tuned. Suppose a landowner wants to build something on their property that doesn't quite comply with your local zoning regulations. Maybe they want to build closer to the street than permitted or exceed the allowable lot coverage. That's one instance when a zoning board of appeals might come into play. ZBAs are required by state statute in any town that has a zoning commission or combined planning and zoning commission. ZBAs are required to have 5 regular members and 3 alternate members unless otherwise provided by special act. Members of the ZBA cannot serve on the zoning commission, nor can they act as the zoning enforcement officer of the same town. ZBAs have a fairly limited scope of review and are more judicial in nature than a planning or zoning commission. The main type of application that ZBAs hear is a request for a variance, but a ZBA also hears appeals of decisions issued by the zoning enforcement officer. In addition, if local zoning regulations dictate, ZBAs occasionally review applications for special exceptions or exemptions. We will discuss each of these in detail, along with a brief discussion regarding location approvals for automobile-related uses. The most common application before a zoning board of appeals is a request for a variance. Variances allow for the zoning regulations to be varied or altered in specific situations unique to the property where the direct, literal application of the zoning regulations would create what is called a hardship for the property owner. Variance applications always require a public hearing to be held. Typical variance requests include reducing required setbacks or increasing the amount of lot coverage that is allowed. A more uncommon variance request is for a use variance, which would alter what uses or stipulations for uses are permitted. In all cases, variances require 4 affirmative votes to approve the application, regardless of how many members are seated. In other words, if only 4 members are seated, they all must vote unanimously for the variance to be approved. Your regulations might have extra criteria on which to judge applications for use variances, so as always, it is important to review your local regulations. The hardship requirement has been determined by the Connecticut court system to mean that the applicant must prove that he or she is being completely or nearly completely deprived of the value of the land as a whole due to the zoning regulations. This is very similar to a taking. Financial hardships of the property owner do not count, and the owner cannot have created the hardship themselves. It is important to note here that once variances are granted, they run permanently with the land and not the property owner. Therefore, the hardship is often an issue with the land or lot itself. If an applicant does not have an adequate hardship, a variance should not be granted. If it were, it could be appealed by an aggrieved neighbor to the Connecticut Superior Court and overturned. So, let's go over some examples of what might be a hardship. Let's say a property owner wants to construct an addition to accommodate a new bedroom for a new child. The addition would go over the required side yard setback by 10 feet. Note that in this drawing, the addition is extending over the setback line. Is a growing family an adequate hardship for such a variance to be granted? The answer is very likely no. The property owner is not being deprived of the use or value of the land. The house that exists is still usable as a house, it just cannot be as large or in the location that the owner would like. Now let's say an applicant bought a piece of land that meets all zoning requirements for building a single-family house. However, once the owner began construction, he or she found that ledge would make it nearly impossible to construct in the legal footprint. As such, the owner applied for variance to extend into the side yard setback by 5 feet. Could this be considered a hardship? The answer here is maybe. The ledge is a unique feature to the land, and it is possible that without a variance the owner might not be allowed to construct a home at all. We would need to know a few more details to make a determination, including where exactly the ledge is on the property, and if the owner could build anywhere else while meeting the regulations. But this hardship might meet the test for a variance. One good test to ask yourself when a variance application comes before you is, does this hardship affect all of the neighbors' lots as well? If the answer is yes, it likely does not meet the test for a variance. If the answer is no, as in the case of the ledge, there may be an argument to be made that a hardship exists and a variance is appropriate. Many ZBAs do not find a clear-cut hardship when granting a variance. Is this a problem? It can be. If the approved variance is challenged in court, the town will very likely lose the lawsuit. This will result in a loss of time and money for the municipality. In recent times, courts have become very particular with what constitutes a hardship. It is not uncommon for variances to be overturned in the court system upon appeal. So it is very important to be cognizant of the hardship requirement and review applications accordingly. And the hardship should always be stated on the record when approving an application. If you find that your ZBA is consistently receiving variance applications for certain requests, it may be an issue with the zoning regulations themselves. For example, if the ZBA regularly receives applications for reduced setbacks in order to locate an air conditioning condenser, it may be worthwhile for the ZBA to recommend that the Zoning Commission reviews that regulation. Zoning boards of appeals also hear appeals of decisions issued by the zoning enforcement officer. This happens when someone is contesting a decision that the ZEO has made. The ZEO might issue a cease and desist order to a property owner that they believe is in violation of the zoning regulations, or might approve or deny an administrative zoning permit. Any decision that the ZEO makes can be appealed to the Zoning Board of Appeals by either the subject party or by an aggrieved neighbor. When the ZBA hears an appeal of the ZEO, the board must hold a public hearing and review the case de novo, which is a Latin term meaning anew. This means that the board must not automatically take the side of the ZEO. They have to give fair consideration to both the applicant and the ZEO without favoritism. They are required to review the facts and interpret the zoning regulations appropriately. If the board finds that the ZEO acted appropriately, either in the case of a cease and desist order or a zoning permit, the ZBA would vote to uphold the decision of the ZEO. If, however, the board finds the ZEO did not follow the regulations when acting, the board can vote to overturn the ZEO's decision. 4 votes are always required to reverse a decision issued by the ZEO. While some appeals may be very cut and dry, some could be much vaguer, depending on how the regulations are written. The board must use its best judgment when reviewing the regulations. If the board is completely unsure, it may be wise to consult the town attorney. In some municipalities, zoning boards of appeals are granted the authority to act on applications for special exceptions, sometimes known as special exemptions. Typically, this will be for a very specific set of uses. These uses will be noted as such within the municipal zoning regulations. These applications do not need to pose a hardship as they are not requesting a variance. Your zoning regulations will likely include a series of requirements for this type of application and spell out criteria that must be met in order for the ZBA to approve the application. In this way, it is very similar to a special permit or site plan application to the Planning and Zoning Commission. As with all other ZBA applications, this will require a public hearing and 4 affirmative votes for approval. The last application a ZBA member might see is for what is known as a Certificate of Location Approval. This certificate is required to be obtained from the ZBA for anyone wishing to obtain a license for the dealing or repairing of motor vehicles. In the past, the statute requiring this has changed somewhat regularly. Occasionally, the certificates were required from the Planning and/or Zoning Commission, or either the ZBA or PZC based on municipal population. However, as of this recording in 2021, all certificates for location approval are to be approved by the Zoning Board of Appeals. There is extremely limited guidance as to how the ZBA should review this type of application. As it is not for a variance, no hardship needs to be proven. As such, the board should use their best judgment in approving or denying a location approval certificate. As always, any questions should be directed to your staff or town attorney. Now let's go through an example of a variance application. Let's say an applicant is before the ZBA asking for a variance for the side yard setback. Currently, the required setback is 25 feet, and the applicant wants to extend an addition to their single-family house for a garage to 20 feet from the property line. Therefore, they seek a 5-foot variance. Which of the following questions should you ask when reviewing the application? A. Would it be too expensive for the applicant to build in a different location? B. How many cars does the applicant own? C. Is something about the applicant's lot different from the neighboring lots? Or D. Will the garage addition match the house aesthetically? The ZBA isn't worried about the individual's personal situation, whether it be financial or otherwise, so that eliminates A and B. The ZBA also does not review aesthetic design, so that rules out D. Therefore, the correct answer is C. If something about the applicant's lot is unique from the neighboring lots, there may be a hardship. Now, you'll want to take a closer look and see what makes this lot unique. Which of these might qualify as a hardship? A. The house is currently at the limit of all setbacks on all sides. B. The house is surrounded by a pond on all sides except for the proposed side. C. The driveway is near the setback limit, so the garage would be best on that side. Or D. The applicant has built fencing along the other sides and would have to remove it to locate the garage there. The ZBA can't factor in things that the applicant or a previous owner caused, so therefore the answer can't be A or D. C is more of a personal preference, so therefore the answer is B. Things like ledges, ponds, and other natural barriers could be a factor in determining a hardship. So, we've determined that the lot is unique and that the unique factor is limiting. What is another question that you should ask before granting a variance? A. Do the neighbors agree that this variance wouldn't bother them? B. Has the applicant resided at the house for a considerable length of time? C. Has the applicant provided photographic renderings of the proposal? Or D. Is the applicant being denied basic use of their property because of the lot limitation? Remember, neighbor approval or opposition is not a quality of a hardship, so A might make the public hearing easier or more difficult, but it is not strictly relevant. B is entirely irrelevant to the application. C may or may not be helpful for the board, but it is not a requirement, so that leaves D. The board should be determining whether the landowner is being denied basic use of their property. In this case, we can't say for certain. The owner is not strictly being denied the use of the lot as a single-family residence, so it may not be worthy of a variance. Remember that whenever the ZBA approves a variance, they should state the reason and hardship on the record, along with the section of the regulations being varied, and by how much the regulation is being varied. This concludes our training video for the Zoning Board of Appeals. If you are a ZBA member, we hope you found it helpful. As in all cases, if you have specific questions regarding your role or regarding an application, it is best to talk to your staff or to the town attorney. Additional videos for public meetings, public hearings, and commissioner conduct are already available, and videos for other municipal commissions will be prepared in the future. Thanks, and have a great day.